a bearing on almost all tax matters which we do. So if we look at the Constitution per se, the four most important articles in terms of taxing powers are Article 245, 246, 246A, which is the Levy of Gst, and 248. Now, if we look at 245 per se, 245 states is the extent of laws made by Parliament and by the legislatures. The article simply states that parliaments may make laws for the whole or any part of the territory of India, and the legislature of a state may make laws for the whole or any part of the state. And no law made by parliament shall be deemed to be invalid on the ground that it would have extraterritorial operation. What I will do is first discuss this section threadbare, then come back to 246. A mere reading of this section makes it very clear that the states can legislate within the territories of the state and the union legislate within the territories of the union or all over India. Now, if we look at the territories of the state, they are set out in Schedule 1 to the Constitution. When India became independent, there were various state reorganization acts which were passed, and the territories of each state is set out in Schedule 1. Now, for most of us who practice in the Madras High Court, we know that the writ jurisdiction of the Madras High Court and the Madurai bench extends to the territory of Tamil Nadu state per se. The contours of Tamil Nadu state are well defined. Therefore, Tamil Nadu cannot legislate in respect of something which happens in Karnataka. The Parliament, however, can legislate for the entire India, subject to Article 246 as well as other articles. The second part is that the parliamentary law cannot be declared invalid only on the ground that it would have extraterritorial operation. Therefore, two questions arise. What is extraterritorial operation? Can you make laws for a territory outside India, or do you make laws for within India which can have extraterritorial operation? I think the law regarding 245 and 1 and 2 are more or less settled, except for two aspects which I just wanted to highlight. The first aspect is the territorial waters of India. Now, who will legislate in the territorial waters of India? Is the right to legislate that of the Union of India, or is it that of the states? Till recently, I thought the position was very clear that it is only the Union
not to play on the mobile because of she's not wearing spec.
To legislate over the territorial waters of India. But on a more careful reading of the provisions, the law doesn't seem so settled.
Karthik sir, if I could interrupt just for a second, sir. Sorry.
Yeah.
So your voice is cracking in between.
Is this better now?
Yes, sir. If you have a earphone, sir.
I'll use a headphone.
Yes.
Is this better now?
Yes, sir.
Okay.
Thank you.
Yeah. So if you look at Article 245, subclause 1, the first question which arises is to the states. When I talk about states, it's the individual states. Do they have the power to legislate over the territorial waters? Now, this litigation has been going on from 1954. The first case, as usual, arose from the Madras High Court, which was AM SSM versus State of Madras, though not in the context of the power to levy tax, but it arose in a different situation. The case which went right up to the Supreme Court was the case of Great Eastern Shipping versus State of Karnataka. This was an issue of the levy of lease tax. Apart from the normal issue of lease tax, one additional issue which arose, because all these were ships, the ships were sailing in the territorial waters. And the contention was that the states did not have the competence to levy sales tax or lease tax on activities in the territorial waters. The Supreme Court said that we will go by the place of the agreement because this was prior to the CST amendment and they followed the 20th century finance decision. And they said we did not need to go into this question. They also diluted the findings of the Karnataka High Court on this issue. Therefore, as on today, the issue as to whether it's the union which has the power to levy tax on territorial waters or whether it's the states which have the power to levy tax on territorial waters still remains open. Now, this issue was also discussed in the various GST Council minutes, and what the GST Council in the 9th GST Council meeting said is that we believe it is the union which shall tax unless the Supreme Court says otherwise. But what we will do is the power to collect state tax in the territorial waters shall be delegated by the central government to the states. When they use the word delegation, it appears to me that it's something like your CST, where the levy is by the center, but the collection is by the state. But on a reading of the provisions of the IGST Act with the state SGST Act, it leads to a different interpretation. I would also invite your attention to Section 9 of the IGST Act, which says that a supply in territorial waters shall be deemed to be in the coastal state or union territory where the nearest point of the appropriate baseline is located. Now, when we look at the Constitution per se, this issue was there in the minds of the framers of the Constitution. It is codified in Article 297 of the Constitution. And the debate is also arising because of the language they have used in 297. They do not say that the territorial waters vest in the union. What they say is all resources in the territorial waters shall vest with the union and be held for the purpose of the Union of India, which is why the states have taken an argument saying that territorial waters don't vest in them. It's only your resources in terms of your oil, crude, petroleum, so on and so forth, which are held with the union. But in my opinion, it is only the union which should have the power to tax in the territorial waters. A reading of the Constitutional Assembly debates prior to the introduction of Article 297 makes this clear. And even if you look at international jurisprudence, there have been some cases in US and Canada. And what they say is that the ownership and sovereignty of territorial waters vests with the sovereign nation and not the individual constituent states. As regards Article 245 subclause 1, I think the only open issue as I see is whether the state or the union have the power to legislate in territorial waters. My personal opinion is the power should be with the union given the nature of our constitutional scheme and international law and issue. But I'm sure the matter will come to the Supreme Court in some time, and that is something which we need to look at. The second part of Article 245(2) is that...
Okay. Thank you very much.
Yeah, can I continue? Yeah, can I continue with this?
Yes, sir. I'm sorry, sir.
Continue.
Yes,
Yeah.
sir. We are able to hear.
Yeah. The second part of Article 245 subclause 2 is that no law made by Parliament shall be deemed to be invalid on the ground it would have extraterritorial operation. Therefore, you will have to understand what is the scope of legislation which Parliament can make and what is the meaning of extraterritorial operation. The two key decisions which we should look at in this context is one is the decision in Bengal Immunity Company, which is a 1955 decision. This was a 5-judge constitutional bench of the Supreme Court, where they said extraterritorial can have two connotations. One is the law in respect of acts or events which take place inside the state, but their operation is outside. This is only intra-territorial. You loosely refer to it as extraterritorial. The second aspect is said is laws with reference to the nationals of a state, which is India as a whole. When they refer to state, they refer to the nation state per se, in respect of their acts outside. Therefore, if you're an Indian citizen or an Indian national and you do something outside India, then India has the power to make laws in respect of that. And that, according to them, was the meaning of the term extraterritorial operation. What they said is that term extraterritorial operation must be understood in this second and strict sense which we are referring to. What happened thereafter is that the same issue came before another 5-judge bench of the Supreme Court in GVK Industries. Before I go into what the court held in GVK, a brief bit of history. This was referred to a 5-judge bench by a 3-judge bench in the case of ECIL. This was because I think they had challenged section 9 subclause 1, subclause 5 or 6 of the Income Tax Act. And when it came to the 5-judge bench, they said they will not continue with the challenge any longer, and they did not want to challenge the constitutional validity of the income tax provision. Therefore, the question of looking at 245 subclause 2 never arose, but at the assertion of the Attorney General that this was an important issue which needed to be resolved, the Supreme Court said, we understand the matter is no longer before us, but we will still go ahead and look at the scope of Article 245 subclause 1 as well as Article 245 subclause 2. What they said is Parliament does not have the power to legislate for a territory other than India. This is well in keeping with the Comity of Nations, where each nation is a sovereign and legislates for itself, and you cannot legislate for some other nation. The second part of it is they said Parliament is empowered to make laws with respect to aspects or causes that occur, arise or exist or may have expected to do so within the territory of India, and also with respect to extraterritorial aspects of causes that have an impact or an excess with India. Now, if you look at this, this is much wider than what was held in Bengal Immunity Company, because Bengal Immunity Company restricted it to citizens of India or nationals of India. Therefore, what GVK has done is to throw the door open very wide. And they said any law enacted by Parliament with respect to extraterritorial aspects of causes that have no impact on or no nexus with India would be ultra vires. Therefore, what they have basically laid down is a territorial nexus test with India. And in terms of the territorial nexus or connection, what they have said is it should be a real and substantial connection. It should not be merely an illusory connection. Therefore, now we have a situation where the law is what GVK has held, and the law is also what Bengal Immunity has held. Now, the important thing to note is that one, the GVK decided an issue which never arose because the councils had given up that point of the challenge to Section 9. Two, GVK did not consider Bengal Immunity Company despite it being a 5-judge constitutional bench. Therefore, in my opinion, even on this aspect, there is a divergence of views by two constitutional benches of equal strength. One bench has not even considered the decision passed by another bench. So I think this is also an issue which will need to be redetermined by the Supreme Court and probably by a larger bench of the Supreme Court. So now that I have touched upon 245, I will now move on to Article 246 of the Constitution. Now, when we look at Article 246 of the Constitution, it can be looked at either as a source of powers or even as a distribution of powers. What it basically says is that in respect of items in List 1 or the Union List, Parliament has the exclusive power to make laws. In respect of List 2 or the State List, the state legislature has the power to make laws. And in the concurrent list, both can make laws, though Parliament will have the prerogative to do so. Now, 246 subclause 4 is also important because it says Parliament has the power to make laws with respect to any matter for any part of the territory of India, not included in a state, even if the matter is one which is enumerated in the state list per se. Now, having seen 246 per se, we will also now look at 246A, which is the levy of GST. I will discuss 246A in a bit more of detail once I finish 246. But if you look at 246A, it starts off with the words notwithstanding anything in 246 and 254, saying that the legislature of every state shall have the power to make laws with respect to goods and services tax imposed by the union or by such state. So when I first read 246A1, I thought it doesn't give you the power to make levy tax. It only gives you the power to make laws with respect to goods and services tax imposed by the union or by the state. But then if you look at the language of 246 also, 246(1), Parliament has exclusive power to make laws, or 245, Parliament may make laws. Therefore, the language of 246(1) is consistent with 245 and 246, which is giving you the power to make laws. Therefore, when we have to see what is goods and services tax, we will have to look at Article 366(12)(a), which says goods and services tax means any tax on the supply of goods or services or both except taxes on the supply of alcoholic liquor for human consumption. And then Article 248 is your residuary power of taxation. It is subject to 246A. Prior to the introduction of 246A, it was not subject to anything. Parliament has the exclusive power to make law in respect of any matter not enumerated in the concurrent list or in the state list. Now, when we look at the power to tax also, what we will also need to look at is there any restriction on the legislative powers under the Constitution to tax? Now, your normal restrictions are that the power to tax anything in the course of interstate trade or commerce vests only with the Parliament, and the state cannot legislate upon the same. You will find that under Article 246A subclause 2, 269A, 269A subclause 5, where Parliament will basically determine the place of supply rules, and also when a supply of goods or services is in the course of interstate trade or commerce. 286, which says no GST can be levied outside the state or in the course of import into India. Therefore, all these are restrictions on the power of the individual state per se to make laws. Now, apart from these restrictions, there are also certain other restrictions in the Constitution. There is an exemption of the property of the union from state taxation. There's an exemption from the property of the state from union taxation. Now, when we look at all the decisions in relation to this, what they say is the exemption is only qua.
It should fall under these three categories. Up.
Yes, ma'am.
Karthik sir, I'm sorry, sir. I think I'll just unmute everyone and again unmute you. I'll not permit them to unmute themselves.
No problem. I can take questions right now if anyone wants to.
Yes, sir. We'll just continue in a minute, sir. 1 minute. Yes, sir. Karthik sir, you can start. I'm sorry.
So if you see, one are the restrictions on who can levy the tax. Two are certain other restrictions like on the property of the union, state cannot levy a tax. On the property of the state, the union cannot levy a tax. Both these are basically analogous provisions. This has been interpreted by the courts to say this applies only in the context of what you know as direct taxes in economic theory and not indirect taxes. Therefore, it is only an exemption from income tax and not from indirect taxes. Now, when I was also looking at this, we both talk about direct tax and indirect tax as if it's something enshrined in the Constitution. But I was surprised to read that there is nothing in the Constitution as direct tax or indirect tax. There is no constitutional division as direct and indirect tax. These are only divisions in economic theory and what we practitioners refer to as direct and indirect. The Constitution doesn't make any such distinction. Therefore, even if you look at the judgments in the context of 285 and 289, they very carefully say this is an exemption from direct tax as known as economic theory per se. Now, if you look at the other restrictions on taxing powers, the states under Article 245, 246, read with entry 60 of List 2, can levy a tax on professions, trade, callings, or employment. 276(2) of the Constitution says that the maximum quantum of tax which can be imposed is rupees 2,500 per annum. Therefore, when you look at your profession tax per se, that is why the amount of profession tax you have to pay is capped at 2,500 per annum. There are certain other limitations saying that the state government cannot levy, or there can be no tax on the consumption or sale of electricity to the government, to railways, so on and so forth. These are there under Article 287 and 288 of the Constitution. I'm just going to skip through the details. You can look at it later. I'll also circulate the presentation. Now, when we look at 246, 246 gives the power, and it's the distribution of powers to tax between the union and the states. Now, what is Schedule 7? Schedule 7 does not give the power to tax. It is what you refer to as a field of legislation. So what the Supreme Court has said is that the legislative power is derived from Article 245 and probably also 246. And the entries in the 7th schedule only demarcate the legislative fields of the respective legislatures. They themselves do not confer any legislative powers. Now, when we look at 246, if you see, there is a mutual exclusivity or distribution of taxing powers. What is there in the union list, the state cannot tax. What is there in the state list, the union cannot tax. Therefore, until the introduction of Article 246A, there was a very clear distribution of powers between the parliament and the state, and the taxing powers of the union and the state were mutually exclusive. Another important point is, if you read all the entries in Schedule 7, there is a distinction between general entries and taxing entries. You don't have an entry which gives you a general power, say, to regulate industries and to levy tax on this industry. Regulation will come under, let us say, entry 1, and the power to tax will come under entry 2. Therefore, that is what Hoish Pharmaceuticals says. If you read the lists themselves, there is a strict distinction between the power to legislate and the power to levy a tax. Now, coming to the fields of legislation, what I've done is set out decisions on each individual taxing entry. I probably will not go through all the entries. I'll just go through a few important entries. One thing which I would like to state is that all these were decisions before the introduction of Article 246A, and whether all the constitutional theories still hold good is something which we need to see on a case-to-case basis. If you look at entry 82 of list 1, that is basically your power to levy income tax. What this case said is your power to levy income tax is different from your power to levy a tax on property. And therefore, the parliament has the legislative competence to levy income tax, because it's a tax on your income, not a tax on property per se. An issue arose later on whether you could levy entry tax on imported goods. It was answered saying, yes, you could. The power to levy customs duty was distinct from the power to levy entry tax. Now, if you look at entry 84, now entry 84 is the levy of excise duty. The case which I was initially talking about, saying that under the constitutional scheme, there is no division between direct and indirect taxes, and it is only a distinction in economic theory, was discussed in detail in this case in Chota by Jetbhai Patel. The retrospective legislation in that case was challenged on the basis saying it was an indirect tax and therefore you could not pass it on to the customers. What the court held is retrospective legislation was permissible. It was only an indirect tax in economic theory and not in legal theory per se. Interestingly, if you look at entry 84, it only says the power to levy excise duty on goods manufactured or produced in India. An issue also came up in Ujagar prints as to what is excise duty levied under. They said it is levied under entry 84 read with entry 97. And they refer to something called a ragbag theory of legislation, which I will come to a bit later in this presentation. I'm just going to skip through this slide. Entry 91 is interesting because if you see it is rate of stamp duty in respect of bills of exchange, checks, promissory notes, so on and so forth. So if you see taxing entries or the fields of taxation are prescribed only in list 1 and list 2. The only field of taxation prescribed in list 3 is the levy of stamp duty. Therefore, if you look at entry 91 doesn't talk about the levy of stamp duty. It only talks about the rate of stamp duty. Therefore, the legislative field of the levy of stamp duty is in entry 44 of list 3 or the concurrent list. This is the only taxing entry in list 3. And it's only the power to fix the rate of stamp duty which is prescribed under list 1. Which is why probably you have the Indian Stamp Act which lists down the rate of stamp duty and the various state-specific stamp acts also. Now, if you look at entry 92B, the reason I've just highlighted this is interesting because initially your sales tax could be levied only on sale and not stock transfer. What the 61st Law Commission recommended was that the definition of sale probably needed to be amended to also include what we refer to as branch transfers. What the legislature instead did is introduce a separate legislative field of taxes on the consignment of goods, which is basically what you refer to as stock transfers. Therefore, under the CST Act, you have power to levy a tax on stock transfer or request for Form F, and if Form F was not given to levy a tax, comes from entry 92B. The decision of Goodyear, India is a good read because it traces the evolution of this and says why this entry per se was introduced. Then entry 9C is an interesting entry because it was introduced for tax on services. This is probably one of the very, very few entries which was put as a part of the Constitution and was to take effect from a date to be notified, but was never notified. Therefore, from its inception, service tax is always traced to entry 97 of list 1 and never to entry 92C of list 1 because it was never notified, and this provision was also omitted by the Constitutional Amendment Act, which give effect to GST. When we look at entry 97, that is what we refer to as the residuary entry, which basically says any other matter not enumerated in list 2 or list 3, including any tax not mentioned in either of those lists. Therefore, the law on this subject is before exclusive competence can be claimed for Parliament by resort to the residuary power, the legislative incompetence of the state legislature must be first established. Therefore, only if it is not a matter in list 2 or list 3 can you impose a tax under entry 97 per se. The two leading decisions on this point are International Tourist Corporation and Union of India versus HS Law. Now we come to the state list. Now, if you see the state list says taxes on agricultural income. Now, I'll just go back to the central list. If you see entry 82, said taxes on income other than agricultural income. That is why I initially stated there is a mutual exclusivity of taxing powers per se. Now, two important open issues are the scope of taxes on land and building. If you levy a tax with respect to the produce of land, or the value of land, will it be a tax on land and buildings? That is something which is now pending before a 9-judge bench of the Supreme Court in Mineral Area Development Authority versus SAIL. And the other thing is the taxes on mining rights. What is the scope of the taxes on mineral rights? There was a divergence in view between India Cements, which is a 7-judge bench, and Kesoram. This is what Sujit Ghosh dealt with in this presentation. Now, most of those issues are pending before a 9-judge bench of the Supreme Court in Mineral Area Development Authority. And that will have a bearing on the scope of entry 49, entry 50, and entry 54 of list 1 person. Now, this was something else which we were discussing during Sujit's presentation. There was a question posed as to whether the tax on electricity, what is it per se? Now, if you look at entry 53, it says a tax on consumption or sale of electricity. Therefore, what the court has held is this is a tax on consumption on sale, and this is not in the nature of an excise duty, but rather in the nature of a consumption tax or a sales tax per se. Then your entry 54, which still remains good, but it is only confined to certain petroleum products. Entry 60, which is your taxes on professions. If we look at the judicial decision on this, it says the state shall have the power to tax, but this shall be subject to the restriction under Article 276, subclause 2, which we discussed in terms of what are the restrictions on legislative powers per se. Now, when we look at the concurrent list, the only taxing provision is that of stamp duty. And what the Supreme Court in C Customs has said is, though various taxes have been separately included, there is no overlapping, no tax in the concurrent list except for stamp duty per se. And apart from the levy of tax, you also have the levy of fees. So these are the entries in the union list, state list, and concurrent list on the levy of fee per se. Now that we have seen the various legislative fields, what we should next understand is how do you interpret these legislative fields? Just like we have principles of interpretation of statute, you also have principles of interpretation of the Constitution, and you have separate principles of interpretation of the 7th schedule to the Constitution or these specific legislative fields. Now, the first rule is that the rule of widest possible interpretation. That means you should give the widest possible interpretation to each entry. The widest possible construction is to the ordinary meaning, and the cardinal rule is that the word should be read in their ordinary, natural, and grammatical meaning in the widest possible manner. The second theory is what we refer to as the doctrine of pith and substance, which means if a legislation substantially falls within the powers conferred and the legislative field, just because there is an incidental encroachment or encroachment into another legislative field, it does not mean that the legislation is invalid. The legislation is very much valid because the pith and substance of the legislation is within a particular legislative field. These are the important cases, Goodyear as well as All India Federation of Tax Practitioners. Doctrine of colorable legislation. This is more a challenge to the legislation per se. What it says is that what cannot be done directly cannot be done indirectly. Therefore, this is more on the competence of a legislature. All you have to look and see is whether the legislature is competent to make the act. You cannot go into the motives of the legislature. If it is competent to make the act, then there is no colorable legislation per se. Now, when you look at the issue of colorable legislation, the questions which need to be asked is what is the pith and substance of the act? Does it fall within any of the entries assigned to it? And can the legislation be read down reasonably to bring it within the legislature's constitutional powers? The fourth is something which all tax practitioners will be very familiar with, which is the aspect theory of legislation. Aspect theory of legislation basically says that though they can be overlapping in fact, there cannot be any overlapping in law. Therefore, the first issue arose in the context of levy of excise duty and sales tax, because both were levied at the sale value. What the court said is that excise duty is on the activity of manufacture. Sales tax is on the activity of sale. There may be some overlap in fact per se, but there is no overlapping in law. These are different aspects of a transaction, and therefore you can tax both the different aspects as long as there's no overlapping in law. The important decisions are Governor General in Council versus Province of Madras, Federation of Hotel and Restaurant Association, and even if you look at All India Federation of Tax Practitioners, they said that taxes on profession is on the professional aspect, whereas a tax on services is on the service aspect. Then the next is the rag-back theory of legislation. When we look at the legislation, all that it says is that you did not draw the legislative field only from one entry. You can draw on it from various entries. A classic example is your annual finance act, something on customs, something on excise. Therefore, all these are drawn from the various legislative fields under list 1. In Ujaga prints, they basically said that the power to levy excise duty can be seen as coming from both entry 84 read with entry 97 of list 1, which is basically the rag-back theory of legislation. Now, when we look at the normal principles for determining the constitutionality of a statute, what they basically say is look at the pith and substance. If in pith and substance it's within a particular legislative entry, then it is constitutional. When the encroachment is only ostensibly ancillary, it is not beyond the competence of the enacting authority. The statute will not be a colorable legislation and will not be constitutionally invalid. If the statute is legislatively competent, then you cannot inquire into the motive which persuaded Parliament to make the legislation. The only issue which I would like to highlight right now is that under this new theory of manifest arbitrariness, as propounded in the Sharia Banu case and used in the Puttasamy case, where they re-examined Article 139A of the Income Tax Act, they said that legislative malice is something which you can look at for the test of manifest arbitrariness. I have my own doubts on how you can call any enactment by a legislature to be malicious per se. And I really don't know how that will work out when we test it practically. Now coming to Article 246A. What I will do is I will just read out the article and then go to a discussion of the article. The article basically says it's notwithstanding anything contained in 246, which means that we don't need to look at fields under schedule both Parliament and the state legislatures. Therefore, this is the first time that Parliament and the state legislature have been given the concurrent or the simultaneous power to levy a tax. Until now, the levy of taxing powers were mutually exclusive. And if you look at any decision all of them so far said that the power to tax between the union and the state are mutually exclusive, except for stamp duty, which was in the concurrent list. Now that has changed with the advent of GST per se. And the power is to make laws with respect to goods and services tax. We have the model laws which are made in terms of Article 279A, and which is now followed by both the union as well as the state. Now, if we look at 246A, 246A is a standalone power to levy tax. It is the only taxing power for which the legislative field is also prescribed in the article itself. And you don't make a reference to Schedule 7 at all. This is the first time there's a simultaneous empowerment. 246A also overrides 246. Therefore, now when we look at all previous decisions in the context of interpretation of taxing entries, that may undergo a sea change, because the entire scheme of 246A is different from taxes which were levied until now in terms of 246 read with the legislative fields under Schedule 7 per se. So what I've done is, I thought I'll just sum up whatever I've said so far, and then I'll be happy to take any questions. And if anyone also wants to give their inputs, because I think this is indeed a very interesting topic, I'll be happy to listen to all your inputs also. Therefore, if you see, prior to 246A, there was a distinction between general subjects of legislation and taxation. There was mutual exclusivity of taxing powers, and the union and the state did not have the concurrent power to levy tax on anything. After 246A, there is a sea change. It's for the first time that the union and the state have been given the concurrent power. And we are hearing new terms such as cooperative federalism, so on and so forth. Also, it's important to note that the power under 248 read with entry 97, which is the residuary power, is vested only with Parliament. And many of us do file writ challenges, including on the issue of legislative competence. Therefore, I thought it's very important to end with what the courts have said. Basically, that it's not necessary for the state to show that the legislature, in enacting the law, consciously applied its mind to the source of its own competence. The competence to legislate flows from 245, 246, now also from 246A and other articles. In defending the validity of a law questioned on the ground of legislative incompetence, state can always show that the law is supportable under any other entry within the competence of the legislature. In supporting legislation, sustenance could be drawn and had from any number of entries. The legislation could be a composite legislation. A rag-bag theory of legislation is particularly familiar in taxation. With that, what I will do is I will conclude my presentation and I'll be happy to take questions. I would also like to thank the organizers for giving me this opportunity, and A.T. Srinivas sir in particular, and also my team members who have helped me greatly with this presentation. Thank you.
So thank you very much, sir, for your lucid presentation. I think you have taken us through the entire constitutional part of legislative powers of levying tax, sir. So thank you very much, sir. Sir, with your permission, we can take up questions, sir. So I request the participants, whoever has any questions to ask, you can raise your hands in the app, or you can just send me a message so that I can unmute you and you can ask the question directly to sir. So I think I have got a couple of questions already. I'll just check. Sir, there's one question, if I could read it out to you, sir.
Please.
So there's one question from Mr. Satyanarayan, who's asking how renting of property is categorized as service.
Okay, so renting of property, the argument which has been taken is that it's nothing but a tax on land and buildings, which is under entry 49 of list 2. This issue is already before the Supreme Court to say that it is not a service, but it is only a tax on land and buildings. I also think that the decision of the 9-judge bench of the Supreme Court in the MRDA case, which I referred to, which will decide on the scope of entry 49, will have a bearing on this. The argument of the revenue are, these are two separate aspects. One is the service aspect, and one is the tax on land and buildings, which is on land and buildings as a unit per se. This is not a tax on land and buildings as a unit, but a tax on the licensing or leasing of land, which is a different aspect altogether. So these are the two arguments and counter arguments. I think we will see the final resolution only at the Supreme Court level.
Thank you, sir. Any other questions? Or else I can just give you the access to so Balaji says, hang on. I'll just unmute him first. Balaji, sir, can you hear me?
Karthik, excellent as usual.
Thank you, sir.
I only have the aspect theory which you have referred to should be, or my understanding is that it should be a conflict between the state and center. May not, or does it operate even within the same legislations? Like, one aspect being taxed by the state and another aspect is also being taxed by the state. Would it be possible, or the aspect theory looks into only one by the state, another by center?
So predominantly it's a state and center, but it can also be the same this thing. Why I'm saying so, I think in the context of entertainment tax and luxury tax, that issue arose.
Entertainment tax and
luxury tax. I'll have to verify that again. Most cases I've seen are between the state and the center. But conceptually, as long as on the same transaction you levy two taxes, that issue can always arise as long as there are factual similarities. What the Supreme Court has done is to basically say that in law there are two different events. For instance, one is a sale event, one is a manufacturing event. Therefore, I think legally you can say that the aspect theory, there may possibly be a situation where the center wants to levy two taxes on the same this thing. Even now when we come to GST per se, on customs duty, and when we also levy IGST on the customs component, someone may ask us whether the aspect theory applies in that case, which is why I'm telling you I'm not sure. But almost in all cases which I've seen till now, it is the union levying on one hand and the state levying on one hand. Also, there has been a lot of criticisms to the aspect theory, and some of the best articles are by Mr. Dattar, which say that the aspect theory as propounded in Canada is based on their constitutional scheme. It's actually a double aspect theory, and it cannot be invoked in India per se because our constitutional scheme is different. This has been argued before the Supreme Court, and I think will continue to be argued before the Supreme Court. We'll have to wait and see.
Why I raised this question particularly is
equalization levies.
One is equalization, the other is similar, where you should be aware, 50C, Section 50C of the Income Tax Act, deems the sale price to be different from that of the actual consideration. Where the immovable property is sold, the guideline value or value at which stamp duty is registered is considered as is substituted for the actual consideration in case that stamp duty value is higher. So accordingly, the seller is taxed. Now, a few years back, maybe about 4 or 5 years or more, provisions are introduced under Section 56 to tax the buyer, saying that you have bought an immovable property whose value for registration is say 1 crore, but actual consideration you have paid only 80 lakhs. So the difference 20 lakhs is to be taxed as a gift in your hand. So it's the same transaction. Already it is taxed in the hands of the seller only through a deeming fiction. And now second deeming is made in the hands of buyer. So whether at all it is two aspects of same transaction itself is, I'm not sure. If it is so, whether there is a conflict. That's why I raised the doubt whether it should be same legislating body or it should be different.
No, I think we'll definitely need to look into that, sir. And also the case which you had sent me, AB Shanti.
Yes.
At least cover the power to tax this, saying that the power to look at it in the hands of the buyer is only an incidental or ancillary aspect. In pith and substance is still an income tax, and therefore you can do this. But
So,
aspect theory is something we'll need to look into.
But here, sorry to interrupt. Here, so it is tax on income on both the hands.
No, I understood. So your power to levy. So I'm looking at two aspects.
Yes.
One is your power to levy. They may be able to justify saying it's an incidental or ancillary power to avoid tax evasion. But the issue of whether the aspect theory will apply was never argued in AB Shanti. Therefore, that's something we'll need to now see.
Yes. Fine.
Thank you, sir. Sir, there is one request from Vardhini ma'am. She's asking your opinion on retrospective amendment and constitution.
Can you be a bit more clear, or are you asking whether the constitution per se can be retrospectively amended, or that any amendment to the statute which is...
She has put up a message in the chat box, sir. She's asking what's your opinion on retrospective amendment and constitution.
No. Okay, let me just address it in two parts. One,
yes,
if
sir.
Retrospective amendment to the statute, you do have the power to amend the statute retrospectively. Normally, the courts will not interfere with retrospective amendments. The only case where the courts have now started interfering with retrospective amendments is where the retrospective amendment takes away a vested right of person. And if it's a constitutional amendment, as long as it's within the confines of Article 368 of the Constitution, you are well entitled to amend the Constitution, though most constitutional amendments are only prospective.
Thank you, sir. Sir, I'm just unmuting Srinivas, sir. I think even he wants to add on. Sir,
the question asked by Mr. Balaji, the aspect theory will not be applicable to AB Shanti case. The classic case will be only the sales tax and levy of service tax and SIM cards only. You cannot import that aspect theory into all the pending litigations or the kinds of disputes which can arise. Definitely that AB Shanti case will not come in the aspect theory. You can proceed to Vardhini question. I think it will be a more relevant question.
Sir, he's already answered Vardhini ma'am's question. Sir, I just thank you. Thank you, Shri.
Still, she wants to unmute.
Yes, sir.
Still.
Mr. Sudarshan? Mr. Sudarshan, can you hear me? I think we're not able to hear him. So the next question from Joseph, sir.
Good evening, Srinivas.
Joseph, sir, we can hear you now, sir.
Yeah, good evening, APS. I would like to differ with you. As Karthik rightly put it, there's no question of direct tax and indirect tax in the Constitution. It is only, as he said, economic theory or whatever. It has no sanctity in the Constitution. So the aspect theory also, there's nothing in the Constitution to talk about aspect theory. There are only lists. There's a schedule. There's an Article 246, 1, 2, 3, which talks about to ensure, the purpose is to ensure that there's no conflict between the state and the center. That's it. The aspect theory is, something which is the nomenclature which is probably invented by the courts. And to answer Balaji's question, whether state versus center or the list 1 versus list 2, something like that, the answer is the aspect theory. Whether the aspect theory is right at all to be invoked in India, as Mr. Dattar has rightly said, if it could be invoked, it could be very well invoked within one particular list itself. Absolutely no doubt about that, because there is a decision of the Supreme Court with respect to additional excise duty, where the earlier the scheme was if a state if a particular item has to suffer additional excise duty, then the state will have to give up the power of levying sales tax on that. So there's a golden tobacco case on cigarettes where Karthik also referred. They levied luxury tax in the guise of sales tax, calling it in a different name. Then they went into this aspect theory and then they said, when your power to levy sales tax, you can't levy one more tax by the state is not permitted. Therefore, the aspect theory will absolutely and very well work within the sphere of one list itself, list 1 or list 2. Yes, sir. Karthik, just input, sir. I'm not able to get a decision.
Yes, sir. I do. I think it was the case of Gordon.
Yeah, that is that on cigarette, the state government levied luxury tax. It was held as unconstitutional because they had explicitly given up the power to levy sales tax on that.
Yes, sir. So I would agree with you. I think aspect theory can be extended to the same list itself, but I will need to look into more.
Vardhini ma'am, I've unmuted you.
Karthik, it was a fantastic session. My question is like, for example, let us take a Vodafone case. There was a retrospective amendment to that particular section, section 9 or whatever it may be. So how do you tend to see in the context of a constitution and the retrospective amendment theory? So I just want your input on that aspect.
See, constitutionally, if you have the power to levy tax, now that power to levy tax is for all times to come. If you look at the number of times the Income Tax Act has been amended retrospectively, I think it will be more than 200 times. Therefore, if you ask, the first question is whether you have the power to amend. The power to amend is both to amend prospectively as well as retrospectively. Therefore, constitutionally, there is no bar on the power per se. If you look at the legislative competence, there is also no bar because you have the power to levy income tax. You will have the legislative competence to amend it retrospectively. The issue which will arise is whether it's violative of any of your fundamental rights. More, I believe, article per se. And now that this new concept of manifest arbitrariness has been introduced, that is something you will need to see whether this is manifestly arbitrary. Because if you make an amendment, let us say effective from 1956 in 2010, then how can you really do that? The second point is it taking away any of your vested rights per se? And the other aspect we'll need to see is, depending upon the nature of the amendment, is it violative of Article 245 subclause 2? But given the very wide expanse of GVK per se, I don't think anything will be struck down on Article 245 subclause 2 for some time to come.
Okay, thank you.
Sir, can I just take up one question from Mr. Aryan?
Yeah.
Sir, his audio is not working, so he just asked me to read it out to you.
Sure.
So he's asking, is service tax on renting of immovable property levied under entry 97 or on the separate entry for tax on land under entry 49? Can a levy be declared invalid on the ground that wrong entry has been invoked, even though the center may have legislative competence under some other entry?
Yeah, Arihant, in answer to your question, see, the main challenge is that 97 is a residuary entry. Therefore, you can take recourse to 97 only if it's not an item in the state list. Therefore, service tax itself is levied under entry 97. Therefore, if someone is able to show that it's only a tax on land and buildings under entry 49, that means you could not have taken resort to 97 in the first instance. And because service tax is levied under 97, you cannot trace the power to service tax to any other entry. Therefore, that's the main challenge. Once someone holds that this is a tax on land and buildings, then your legislative competence and legislative field are confined to 49. You can't go to 97. And you cannot trace the power to the center to any other entry because it's already covered in the state's power to tax.
Thank you very much, sir. I think he would have gotten the answer for sure. There are two more questions. We will take up two more questions. Before that, to all the participants who have missed this session, you can we will be uploading this session on YouTube, so you can always access to our YouTube channel, and then you can always view our webinars till date which we have conducted. So thank you. I will share the YouTube link in the chat box, so whoever has joined us today can always get access to our webinars there. So we'll take up last two questions, sir, with your permission.
Yeah, please.
Mr. Sudarshan, can you hear me now? Mr. Sudarshan? I think he's not. We'll go to the next question. Mr. Renganath.
Yeah, Karthik, good afternoon. Can you hear me?
Yeah.
Yes, sir.
Yeah, please.
Yeah, Karthik, my question is regarding this lack of distinction between direct and indirect tax in constitutional law.
Yeah.
While it is true that there is nothing expressly stated in the Constitution which distinguishes the two taxes, I was just wondering whether this Chota Bhai Jeet Bhai considers the argument that excise duty is nomen juris, the way Gann and Dunkerley considers vis-a-vis sales tax. And so considered, excise duty is always understood as being a tax which you can recover from the buyer. And if that aspect is considered, I mean, my first question is, has it been considered in Chota Bhai Jeet Bhai? And two, if it's not been considered, in your opinion, would it have made a difference if that was put to the court to contend that Parliament cannot have a retrospective levy of excise duty under Entry 84?
Yeah. Ranna, thank you. To answer your specific question, that was considered by the court. And the distinction is in Gann and Dunkerley, what they said is the expression sale per se is nomen juris. You will understand it in the sense in the Sale of Goods Act. Now, what they said is that they considered the history of excise duty. And in excise duty also, though the normal norm is to pass it on to your customer, by way of contract, otherwise you can decide that you will not pass it on to your customer. Therefore, the passing on of excise duty, even though it is presumed under law, is subject to contract to the contrary. That applies to all other indirect taxes also. This issue was once again considered by Justice Rohington Nariman in Bengal Shrachi Housing Society. I think that came about 2 years back.
That's right, yes, yeah.
And they again said the same thing, that it is only in economic theory and not in constitutional law after considering all the decisions. Therefore, what I now think is that maybe the principle of manifest arbitrariness will apply to say that indirect tax legislations as known in economic theory cannot be retrospective. But I don't think we can go back to saying that the Constitution now makes a constitutional distinction between direct and indirect taxes. I think probably the concept of arbitrariness and manifest arbitrariness will be a greater sword when it comes to these challenges.
Thank you.
Thank you very much, sir. I think there's one more question. Sir, Mr. Sudarshan, I think there is some audio issue with him. He has just sent the question to me. If I'll just read it out, sir. I'll just read it out to you, sir. Karthik, sir?
Yeah, please.
I'll just read it out. So this is with regard to extraterritorial legislation versus I think just put it is clear that there is no distinction between direct and indirect under the laws. However, the Supreme Court in GVK on residence versus source on the tax principles mentioned that consumption can be source. So the court is resorting to an economic principle. How do you see this interplay? I'll just copy paste that message so that even you can.
If you can just do that so that I can.
Yes, sir.
See, all taxation is economic. When we look at the source rules per se, These source rules are basically economic theories. Therefore, I would think that what GVK has said is very, very wide in nature. But what we'll also need to look at is what is the nature of the connection with the income which is derived in India. If the connection is a real connection, then you can say in terms of GVK, the law is valid. But you will have to look at it with a connection to the income derived. And if that income is merely illusory, then I think you can say that it is beyond Article 245 subclause.
Thank you very much, sir. So I think we have, I think he's put up the question. He's just supplementing his question more. If we can just clear that and we can end the session after that, sir.
Yeah, see, Sudarshan, as regards equalization levy, I think the user being in India, you can directly say that the source or the activities from which the company derives income is from India or an India related activity. Therefore, I wouldn't think that it is unconstitutional because of Article 245 subclause 2, because there is a real link with the income being derived from India or the activity from which the income is being derived. I'm sure NB Balaji can also supplement that. But at least the equalization levy on that aspect, I wouldn't look at it as an issue. But my issue with the equalization levy perhaps is that it is on the same aspect or same aspect as a supply of a service per se. Therefore, you are levying an equalization levy on an aspect which you're already taxing to GST. Article 246A being a non-obstante clause. Therefore, the question which would really arise in my mind is, once you have levied a GST, then can there be a levy of an equalization levy? And also in the context of equalization levy, if I remember, the first subcommittee said it's not an income tax which we are levying because they didn't want to give it the benefit of a DTAA. Therefore, they traced the equalization levy back to entry 97. And what we'll need to see more than 245 subclause 2 is the interrelation between 246A and entry 97.
Absolutely.
Yeah. Prithvi, I think there's one more question. Should I just answer that? Rajasthan?
Yes, sir. Yes, sir. Sure, sir.
Yeah. So, okay. I presume that this is a reference to the Rajasthan Chemist Association decision, where they said in the first sale, you cannot tax it on the MRP. Now, that has nothing to do with the power to tax. That is more with the valuation to tax. So, MRP of goods is basically the MRP for the final sale. Therefore, when the first sale was on a transaction value basis, I think what the court said is that the value should have a relation to your taxable event. Your MRP does not have a relation to the taxable event per se, because it's on a transaction value basis, and your first sale cannot be taxed on an MRP basis. I think that is what the decision said. I think in terms of law, that will still be good law, because your value should always have a connection to the taxable event per se.
Also, sorry, I'm not sure whether I can take one more now. Prithvi, you will have to moderate whether I can take one more question.
Yes, sir. Sure, sir. You can take it.
Sir, yes. If you can first throw light on equalization tax, then you can take.
I think equalization. You have the point that but for in particular the once service tax is levied and now GST, to use it as a same principle once it is a service simultaneously to take. That's where in fact there is no specific entry for levy of that as well. Whether it will have the character of income is the subsequent question. Once it is classified as a service and now supply and being taxed through a central legislation, then it comes back to the same aspect theory as to whether it will have two aspects: one aspect of supply, one aspect of income.
I think that is why you asked that question also in the first place.
No, I did not. Very honestly, I had only 56 and 50C in mind. And nice that you reminded me, since we had discussed the same thing in the past.
Karthik, I thought I'll just
Yes, Joseph, I'll close with.
Go on,
I'll
Balaji.
close with. Sorry.
Please, please.
You had. Yes.
It is one
You had
point only I
also
wanted to
mentioned.
supplement.
You will. I'll finish this question directly.
Yeah, please.
Karthik, you had also mentioned that the list per se does not give taxing power, and the taxing power arises out of separate provisions only, separate other articles of the Constitution, and list 7 by itself does not give the taxing power. And that it could be supported by any article. Do you see any article other than this 246, 246A, etc., to support taxing legislation?
I don't see, sir. I only see 245, 246, 246A. And to specifically reply to your question, the Kerala High Court, in the case of Sheen Gold Jewels, had said that you are a sovereign and you have the power to tax. And they relied on another Supreme Court decision, which was, however, in the context of the, I think, Assam State Reorganization Act. Therefore, even though you are a sovereign, your power to tax has to be traced to the Constitution. And I think your power to tax can only be traced to 245 to 248. I don't see any other provision. All the others are in the nature of restrictions more than the power to taxes.
Okay. Yes, Joseph. You wanted to add something?
Yeah. No, actually, I was giving that example of additional.
And 1 minute before you proceed, you are one. You only said within the same list, two aspects could be seen, not necessarily between two different lists. I want you to specifically supplement that.
No, that's exactly I'm coming to. I was giving of the gold and tobacco cigarette luxury tax on sales cigarettes, where the state had expressly given up their power to levy sales tax because additional excise duty, AED, will be levied by the union government, and then the entire share will be given back to the state. So the sales tax power to levy sales tax was given up. So what the government did, they wanted to levy luxury tax. They said the sale is a separate aspect, this is luxury is separate aspect. So there was a conflict. So they examined, and the conflict arose between the power of the very same state government only, list 2 only, to levy two different types of taxes. Aspect theory was actually talked about, referred to, discussed in that. But then I thought that an easier, simpler example is there, which I forgot, is the entry 52 of list 2, which talks about the entry of goods into the state for local area for sale, consumption, use therein. Vis-a-vis entry 54, which talks about sale of goods in the state. Entry 52, entry tax. Entry 54 is sales tax. Both come under list 2 only. And there is a 2018 landmark judgment by the 9-judge bench, levy of entry tax by the government, the respective state governments, which is nothing but aspect theory on the very same item. Suppose I get a car from a motor vehicle from, say, Gujarat into Tamil Nadu, I'll have to pay entry tax first. Then when I make a sale of that, I'll have to pay sales tax on that. Both are levied by the state government. One under entry 52, the other under 54. So therefore, on the constitutional validity was argued. One of the grounds was aspect theory. So the aspect theory principle, as Mr. Datta said, if it will apply, it will surely apply within the same list. That's what I wanted to say.
I would only request you to post the citations of these two decisions either in the group or send me independent.
No, I will send both. I'll send both. In fact, the entry tax is very well known because that's a very recent one. That's a 900-page judgment. In fact,
I remember that. I remember the large judgment
case.
That matter which went to this thing. The judges, Justice Bhanumati also is there. Actually, in one of the, I think, in one of while arguing some matter with somebody, Justice Sivananam casually asked, "Have you read the judgment? Excellent judgment." It has just come few days before that. It's a 900-page judgment. It will take about a month for anybody to read it. So he very casually asked. In fact, I only read the portions of that. It is too big. I mean, it a little glance.
Yes, obviously.
This post, that's I think well known. But the other one is more interesting. That additional excise duty was vis-a-vis luxury tax.
Sir, just a minute to interrupt, sir. I will just we can just have an informal discussion now among our members, whoever is present, as we have time. So, but before that, I will just